What we called on Chief Justice Roberts to do is to accept the responsibility at the court. As Chief Justice of the United States Supreme Court, he has to understand that Clarence Thomas's conduct is absolutely unacceptable from an ethical basis. To restore the integrity and the reputation of the court, they have to do something. An investigation followed by a change in the approach on ethics.
Things are heating up for the Supreme Court's longest-serving justice as Democrats call for Clarence Thomas to be held accountable for his alleged ethical lapses. According to reports from ProPublica, Thomas has been showered with several hundreds of thousands of dollars worth of gifts from right-wing billionaire Harlan Crow in the form of private jet and yacht travel, a real estate sale, and other perks. And he never disclosed any of it. Additionally, Thomas's wife, Ginny, collected a salary of nearly $120,000 surreptitiously funded by Crow, and Justice Thomas's disclosure forms for 20 years said she had no employment income. Meanwhile, Chief Justice Roberts has been absolutely silent. So, who's watching the Watchers? Joining me now is someone who is watching the Watchers, Walter Shaub, Senior Ethics Fellow at the Project on Government Oversight and the former Director of the U.S. Office of Government Ethics. Walt, you had a busy time during the Trump administration when it came to ethics. Still going, it looks like. What do you think about Chief Justice Roberts? Do you think he should testify before the Senate Judiciary Committee about judicial ethics? And what would you like to see done if he absolutely refuses to do so?
You know, I think it would be positively disgraceful if he refuses to speak testify in front of Congress. It would be a real statement that these Supreme Court justices view themselves as rulers instead of public servants. They owe us a response. They owe us transparency. And Roberts himself has been disdainful of government ethics, writing in a 2011 year-end report, basically hands off. The court should be able to regulate its own affairs. Well, obviously, they cannot regulate their affairs. I don't know that there's much Congress can do if he refuses to show up, because, of course, to enforce a subpoena, you have to go to court, and that would end up in the Supreme Court. So, unfortunately, that's a no-win situation. But I think Chief Justice Roberts owes us a response, and shame on him if he doesn't. It'll only further erode public trust in this court.
Retired Justice Stephen Breyer, in response to questioning to share his views on Clarence Thomas, said that he thinks Clarence is a, quote, man of integrity. Breyer then went further to say that the problem with the code of ethics for SCOTUS is that justices cannot be replaced if they disqualify themselves like a lower court judge might do. Walt, is that really the biggest impediment to ethical oversight on SCOTUS?
No, shame on him. And of course, that's a word I just used, but it's worth using over and over again with these justices. There's this culture of exceptionalism on the court that we are somehow above the law. The reality is that he may have some concerns about recusal, and that may owe to our current structure of the Supreme Court, where there is no one who could fill in. First of all, we lived with only 8 justices for a long time after Mitch McConnell refused to confirm Merrick Garland or even hold a hearing on him. And the court didn't issue any dramatic or radical decisions compared to what they're doing with a supermajority. I think more importantly, a code of ethics would include things like gift rules, so that there would be a question about whether these kind of lavish gifts could be accepted. And if you believe ProPublica's reporting that rental of the plane would have been $500,000 for one trip, or rental of the plane and the yacht on one trip, we're talking gifts that could actually potentially amount to millions of dollars worth of gifts. And I'll just add that the Department of Justice routinely prosecutes federal employees. There are 26,000 federal employees who file public financial disclosures and almost 500,000 more who file confidential disclosures. So the idea that all of these lower level employees should be subject to either criminal penalties or civil monetary penalties, but the justices shouldn't be, that goes back to that culture of exceptionalism. They think they're above the law.
Well, 2 Democratic congressmen for now, only 2, but I think the number's growing. They're requesting that the Judicial Conference refer Justice Thomas like you were talking about right now, to the U.S. Attorney General for potential violations of the Ethics in Government Act. What would that entail? You talked about potential criminal exposure, but I think more realistically, we would be looking at civil monetary penalties.
Yes. And in fact, the Judicial Conference should do that. But the Supreme Court claims the Judicial Conference has no authority over it. Chief Justice Roberts made that point quite vigorously in that 2011 year-end report. So the heck with this Judicial Conference. The Attorney General can act on his own. And there are mechanisms for criminal prosecution and civil monetary penalties. A colleague of mine at the Project on Government Oversight, Sarah Turberville, and I filed a complaint last week with the Civil Division asking them to pursue civil monetary penalties against him. And we're talking $71,000 potential fine per omission. So if they can prove 10 omissions, you've got $700,000 in fines. That's nothing to sneeze at. And the burden of proof is much lower in civil cases. They only have to prove it's more likely than not that he did this willingly and knowingly. And I think there's ample evidence suggesting they could prove that case.